This podcast is being brought to you by LegalYogi.com.
And I'm here with attorney Jennifer Milne of South Florida Legal Rescue out of Palm Beach County. Jennifer, hello. Thank you for being here.
I'm so happy you invited me, Christy. How are you today?
Oh, good. We're going to have a little discussion today. I wanted to ask you, first off, as a West Palm Beach, Florida attorney, what is the most common question dads in your area are asking about child custody?
I get a lot of questions about access to your child, about visitation, and whether or not it is tied to payment of child support, actually. And there's a lot of dads, the economy is really, really tough right now, and there's a lot of dads who have child support payments that they're obligated to pay, and they just can't find jobs. It's not that, they're the proverbial deadbeat dad. They're good dads. It's just the economy is really tough out there. So I get a lot of questions about child support modification.
Yeah, I wanted to ask you, is there a difference between time sharing and custody? I guess there's different legal terms.
Well, some states use the term custody, and the Florida, where I practice, they use the term time sharing. And Florida moved away from the term custody because it encompassed other terms like visitation and, the custodial parent. And Florida really wanted to emphasize that it's a shared responsibility, that one parent isn't visiting their child, which, when you really think about it, is a horrible way to put a child's relationship with their parent. So some states still use the word custody, but in Florida and a few other states, it's part of the shared parenting paradigm, and the term time sharing is used instead.
So they play a larger, more equal role in the child's life.
Well, yeah, and Florida is one of the really good states about recognizing the rights of dads and the rights of moms, because in a lot of states there isn't a presumption of a 50-50 timeshare split. In Florida, there is that presumption of the 50-50 timeshare split, and if one of the parents is looking to significantly, deviate from that, they're going to have to prove that the other parent is unfit.
And what did you call it, a 50-50?
That is really different from other states. So,
I was going to ask, no, I'm sorry, I was going to ask you, what they call it, a 50-50 time sharing, and I didn't hear that last part.
No, they just call it time sharing, but it's a rebuttable presumption that the parents should split the time sharing pretty equally, that it shouldn't be, a standard visitation where it's every other weekend and a Wednesday, which is, this used to be the standard, is still considered standard, but it's just the party who doesn't want to share the child 50-50 is going to have to show why. The burden's on them to show why the other parent is unfit and shouldn't be allowed to have a 50-50 timeshare.
And it seems, based on your previous comment, that it should not be connected to child support. If I don't have a job, I'm unable to pay my support payments, that does not mean that I should not be able to share time or be part of the parenting plan.
Absolutely. Whether or not you can pay child support has nothing to do with your time sharing, your access to your child. I mean, it does come up in the same proceedings, and you should always pay your child support, but some people just can't. They don't have enough money to live at the end of the month. They're caught in a quandary. I mean, there are literally people out there who are tied into this enormous child support payment, and they may not make their rent, and so they're really stuck between a rock and a hard place, and they simply can't make the child support payment, and that's when you would have to go for, a downward modification on the child support. Because you shouldn't not see your child because you can't afford to keep your child. That is just not right.
Right. Do courts award custody based on gender preferences?
Well, states like Florida have really moved away from the gender preferences. There are some cultural biases that, you do come across, but things like, it used to be that there was something called the tender years doctrine, and it was the presumption that a child was in their younger years was better off with their mother. But, the roles of women have changed, as have the roles of men. And so most states have abandoned the tender years doctrine. I don't know of any states off the top of my head that still use it. There might be some, so don't quote me on that. But some states have moved to another standard called the best interest of the child standard. And they basically say, well, what's in the best interest of the child? Now, here in Florida, they don't do the best interest of the child standard. They do the presumption of the 50-50 split. And that's good, because in these states that do the best interest of the child standard, it's really, really hard because the judge has a lot of discretion in deciding what's good for the child and what's not. And even though it may not be in the findings, a judge could find, that it's not in the best interest of the child to be with their dad. They may go into it with cultural biases, and it's a more difficult situation. They're not supposed to do it, but, it's really, really hard to hold the judge's feet to the fire because it's the judges have such broad discretion.
Well, I do want to thank you very much for your time today.
You're very welcome, Christy. Always a pleasure.
And that will conclude our show.
This podcast was brought to you by LegalYogi.com, providing hundreds of free legal consultations every day since 1999. Our database contains over 160,000 legal and financial professionals, and our phone line is open 24 hours a day, 7 days a week. If you would like a free legal consultation, you can call 1-800-397-1755 from any state in the U.S., and we'll be happy to provide you with a free legal consultation. Our web address and phone number are on the podcast image for your convenience, or you can simply go to LegalYogi.com. That is legal-yogi.com.